Because of disputes like this, I will never run out of topics for these videos. I'm Andrei Mincov, the founder of Trademark Factory, and in this video I'm going to share my thoughts about yet another trademarking screw-up. This time around, it's two companies fighting over the name EXP. Let me read it from the article, and you can always find the link in the description below. Virtual brokerage EXP hit with trademark suit on heels of New York launch. Okay. Less than a month after launching in New York City, virtual brokerage EXP Realty is in hot water with a local competitor claiming trademark infringement. In a lawsuit filed Tuesday, EXP Realty Advisors, a boutique commercial real estate firm in Midtown, accused the newcomer of false advertising and cyber squatting after it allegedly registered domain names and social media accounts that are confusingly similar to its own. According to the suit, EXP Realty Advisors has been in business since 2009, so 10 years. Although it never registered with the U.S. Patent and Trademarks Office, it's been using certain marks or logos to advertise its services for the past decade. It's funny, we just finished recording a video workshop. One of the mistakes that I talk about all the time is, well, I've been in business for 10 years. I don't need to register my trademark. And this is exactly on point. The exact example of, yeah, you can be in business for 10 years doesn't mean that you own your brand. That's why you have to go through this nonsense that I'm going to share with you as I keep reading the article. So let's keep going. In the complaint, EXP claims that EXP, so EXP all capitals, claims that EXP with just an X capital was fully aware of this fact. In April, the suit said an affiliate of the virtual firm named Robert Creamer emailed EXP to ask about acquiring the name EXP Commercial since it was planning a foray into commercial brokerage. Despite EXP's resistance, the suit said EXP had continued their use of confusingly similar marks and in fact have begun to use such marks in connection with commercial real estate services. Earlier this month, EXP alleges a residential agent in New York mistakenly wrote to the commercial brokerage asking to join its ranks. Founded in 2009 by CEO Glenn Sanford, EXP is one of the fastest growing residential brands in the US. It had 15,570 agents at the end of 2018, up from 2,401 in 2016. It's since surpassed 18,000 agents. Interesting. I think they actually made a mistake in the article because the real estate company, the one that was founded in 2009, is the one with all caps, not this one. So even the journalist was confused between these two names. That's really funny. All right, let's keep going. The Bellingham, Washington-based firm launched in New York City this month after hosting info sessions for agents at the Park Lane Hotel in April. Kim Canvan is EXP's managing broker for New York. Matt Pirelli is heading EXP's New York City operation. In the suit, EXP said it was seeking damages to be determined at a jury trial. It also asked the court to have EXP destroy all labels, brochures, social media posts that are confusing and cancel its website or transfer them to EXP. All right, so the demands are usual for any trademark infringement lawsuit. Stop infringing, destroy any signage, destroy anything that has the name that we think might confuse people into thinking that you are us. And if you've got social media profiles, if you've got domain names, give them to us, because simply canceling them is not going to help because anybody else can get them. So the demands are, nothing unusual there. Some money and all of that. Now, there's a couple of things. What I'm really wondering here is which of the parties is making a bigger mistake, or has made a bigger mistake. Now, first we have this real estate company. It's been in business for 10 years and had not bothered to protect their brand until they figured out, there's actually some value in our brand, and somebody else may want to copy it. And when they do, what are we going to do? Well, let's sue them, right? But suing them is going to cost you tens, probably hundreds of times more than it would have cost you to trademark your brand in the first place. Which, again, if you didn't intend to protect the brand and enforce the brand, well, maybe you should come up with a different brand that actually matters something. Maybe you should have come up with a different brand that would have meant something to you. But let's say, all right, so you decide to protect the brand after it's been infringed. Why not do it before, when it costs just a tiny little fraction? So that's one big mistake of this real estate company that they said they've been in business for 10 years, and only now they realize that it might be a good idea for them to own their brand. On the other hand, the newcomer is also making a huge mistake, because now they can't plead ignorance. They can't say, well, we didn't know about this other company because they hadn't bothered to trademark their brand, right? They approached the other company. They showed them their cards and said, we want to be able to use this brand. And the first company said no. And that by itself creates the presumption that the second company knew, and that they did it despite resistance from the first company. And that is a big problem, because again, they can't, with a straight face say that, we never knew this other company. We just thought it was a good name and decided to use it. They specifically went to them, they asked, they got a no. And that's always the danger of seeking consent before you do anything, right? There's always this dilemma. There might be a trademark that's too close. What do? Do we go reach out to them and see if they're okay with that? And if yes, then that's, of course, the perfect solution, because that means that we can confidently file a trademark application and we'll go through. And if it doesn't, we have the consent secured already. But the risk is, if they say no, and you still file a trademark application, or you still go out there and try to use this brand, then what? Then it becomes a problem, because you're on record showing that you've given them notice, and they have given you notice that they are not in favor of you using their brand, right? So the alternative to that is you file, you start using, and if there's a problem with a trademarks office, for example, they send you an office action, say, well, there's this other trademark that's too close, then you can reach out and say, oh, we didn't know, we had no idea, but the trademarks office told us that your trademark is too close to ours. Would you be okay giving us consent? So the advantage of that is you can still, have a story around you not knowing about this other trademark, and you being able to say, well, we tried, it didn't work, we're not going to do it, without attracting too much of anger from the other side. But the downside of this option is that it takes time. It takes time before you hear back from the trademarks office that's going to say, yep, this other trademark is a problem. So during these 4 months or 6 months or 9 months, depending on which country, what are you going to do, right? Are you going to sit and wait, or are you actually going to start using the brand? And starting using the brand could be a problem. So anyway, there's all these competing options, because if you know there's this other trademark out there, you already know you're compromised. You already know you don't have a unique brand. You already know that in the best case scenario, you'll have to coexist with somebody else's similar brand. And that means that even in the best case scenario, your trademark would not be as strong as it would have been had your brand been totally unique. As I always say, different is better than good, unique is better than great. So if there's somebody out there that's going to prevent that brand from being unique, maybe it's time to consider changing the brand. But if not, then you have to figure out, what has the greater risk. You showing them your cards early on and say, look, before we file, we would like to secure your consent. Is that okay? If they say yes, great. If they say no, then rebrand. Or you wait until it's inevitable for you to go and seek consent. Again, if you get the consent, great. If not, then I guess you'll have to go back to the drawing board. So I hope this makes sense. I hope this is useful. And if you can come up with a unique brand, you should. And if that's what you got, make sure you protect it. By the way, if you want to do it with us, with Trademark Factory, we can do it for you with mandatory comprehensive trademark search. And we want to make sure that what you came up with is trademarkable. You got one flat fee that covers everything from start to finish. You got a money-back guarantee and all of the other amazing things that make Trademark Factory different from any other law firm or trademarking company out there. So if that's you, go to trademarkfactory.com, book a call with our strategy advisors, and we'll take it from there. If you haven't subscribed to this channel yet and you found this video interesting because you're an entrepreneur, you're a brand owner, you want to know more how brands work, how trademarks work, subscribe now and get notified whenever the next video goes live. And until then, I'll see you in the next video.